Thank you for that wonderful introduction. We've got a bit to get through this afternoon, but before I get started, I just wanted to acknowledge and pay my respects to the Turrbal and Yugara people, to the elders past and present, those who have passed before us, to extend that respect to members of First Nations communities who are attending here today. Firstly, this is general information only. It is not legal advice. It's not tailored to your circumstances. And if you should like to seek legal advice, please contact a solicitor or myself after this event. It's a bit of a rough outline of what we're going to talk about today. So we're talking about what is disability at law, what laws protect people with disability, the Anti-Discrimination Act, Human Rights Act, and taking action. Now, I could talk about this all day. I love this stuff, but we will try and keep it brief. There is quite a bit of material, so I will try and get through it, and I will try to make it as accessible as possible. It is the afternoon session after all. And please, if you've got any questions or comments at any time, please, I welcome them. We can talk about it through. It is hopefully more of a conversational topic than a lecture. So it's always good if we have some interaction. So what is disability? Disability is defined under the Disability Discrimination Act, and you can see it's quite a broad definition. So total or partial, loss of body part, mental functions, malfunction, malformation, disfigurement, disorder, illness, disease, past, present, future, and behaviour that is a symptom of disability. So it's exceptionally broad. So then we look at, okay, that's disability. What laws protect people with disability? And we've got two tiers in Australia, being a federal system. So we've got the federal or Commonwealth laws, and then we've also got state laws. But firstly, I'll just canvass the Commonwealth laws. I've written them up there. There's been a lot of development over this in the past 40 years or so. Discrimination isn't new, unfortunately, but laws to enable people to remedy the discrimination and enforce their human rights, they are new. We'll be looking next at the state laws, and I've put the selection of them up there. You'll see that the Human Rights Act was only introduced in 2019, so that's very recent, and that left practitioners scrambling to get across the legislation. But we do welcome the introduction and are glad for it. In addition to these acts that have been passed by Parliament, we've got judge-made law, which is called common law, which arises from the cases that are tested. So, for disability discrimination, we've got an interface, essentially, of state law and federal law. They cover much the same topics, however, there are gaps in between, and it can be difficult to navigate which law firstly applies, and secondly, which law is going to give you the best outcome. So it's something that I do suggest you get advice on because it is nuanced. Having said that, once you identify the law, then you're able to take action under it. So there's so much legislation. What I'm going to do today is just focus on the Anti-Discrimination Act in Queensland and the Human Rights Act, which is that newer legislation. So let's talk to the Anti-Discrimination Act. What is it? It's an act that protects people in Queensland from discrimination based on 16 attributes or characteristics, includes race, age and sex. It outlines the areas where discrimination is unlawful, for instance, work, school, university. It does include vilification and sexual harassment, and it is currently under review. Unfortunately, submissions have closed, but there were worthy stakeholders who did provide submissions with regard to the review of the legislation. And there is a report due in June, so I'll be interested to watch this space and see what comes out of that report, just to ensure that the legislation remains current and that any bugs essentially can be worked out of it. Times have changed since the Act was introduced in 1991, so it is important to keep with the times, as it were. With regard to discrimination, there are a number of different types. There's direct and indirect, unlawful and lawful. So let's talk about when discrimination might be lawful. It's not always unlawful. There are some times when discrimination is okay. Those circumstances are called exemptions at law, and the Act outlines a range of exemptions. Some exemptions apply to all areas of the Act, and some are very specific. And they don't always apply. So it really is a case of it depends on the circumstances. If someone complains of discrimination, generally what happens is the respondent, who is the person or business that the complaint is being made about, they must raise and argue that the exemption applies. Exemptions allow certain types of conduct or activity, and it helps balance the need for rules generically with the need to adapt those rules to make sure that we have inclusion. So an example of lawful discrimination might be setting aside car parks for people with disability. Not only do we think that that's suitable morally, but it is discrimination because people who do not have disability can't park in those parks, but that's reasonable. So that's an exemption to the laws. Then we talk about direct versus indirect discrimination. So direct discrimination is on the basis of an attribute, and that happens if a person treats or proposes to treat a person with that attribute less favourably than another person without the attribute who would be treated in those same circumstances materially differently. We'll talk about attribute in a minute. Indirect discrimination, however, so that direct discrimination is if a person has a particular attribute. Indirect discrimination is on the basis of an attribute if a person isn't able to comply with the term. We still need a comparator. So the person with the attribute isn't able to comply with that term. A higher proportion of the people without the attribute are able to apply, and it is not reasonable. So, in order to be unlawful discrimination, we need the discrimination to be based on an attribute. We need it to take place in the area of an activity listed, and it needs to result in you being treated less favourably by someone without the attribute. So, what do I mean by comparator? And comparator, you can see at clause 3 there, is a comparison. So we've got a person with the attribute being treated less favourably than someone without the attribute. And as was just canvassed recently in our discussions with regard to the amendments or the ability to enforce a remedy with the Anti-Discrimination Act, sometimes it can be really hard to find a comparator who's suitable. So you're going to need to provide evidence that a person without the attribute would be treated in a different manner. So that's an additional layer of complexity. So you're going to have to demonstrate those 3 elements plus find evidence about the comparator. So it ends up being quite a high bar that you need to demonstrate in order to be successful in your claims. Again, it really depends on the circumstances. Sometimes it's going to be easier than others. Sometimes in a case of direct discrimination, it's really quite clear. But in a case where there's indirect discrimination, it can be quite nuanced and it can be quite difficult to gather evidence. So it's not as clear-cut as it might first seem. Let's talk about the attributes. So the attributes listed in the Act, you can see there's quite a variety there. And you'll note that impairment is included. So then the question is, what does impairment mean? Impairment means total or partial loss of a person's bodily functions, including the loss of a person's part of their body, malfunction, malformation, disfigurement, and so on, conditional illness, reliance on support of a guide, hearing aid, assistance dog, remedial device. So it is fairly broad-ranging, it is fairly complicated, so you need to demonstrate quite a number of elements. And getting evidence is pretty tricky. So then the definition, what you needed to satisfy also included an area where the discrimination occurs. So you need to have an attribute. It needs to be unlawful. It needs to be in an area. And these dot points here list the areas. So it's quite a broad range, including education. It would be interesting to note there was recent controversy around a particular school in Queensland, but unfortunately that sits outside this legislation, being a school that isn't a public school. So there are limits to this legislation, unfortunately. It has to be in one of these locations, and it's not carte blanche. I'd like to say it's easy. I'd like to give you the answer, but in the event that you're not successful under the Anti-Discrimination Act, it is potential that you have a remedy under the Human Rights Act, and it is refreshing to know that we have that legislation in place now. So let's look at the Human Rights Act. There are 23 rights listed, which is fantastic. Does anyone remember how many rights we had previously? Pretty much none. The Constitution allows freedom of movement. That's pretty much it. So a lot of people weren't aware of the need for us to have these rights entrenched. So as a solicitor, it's refreshing to have those written down in legislation. So not only are there rights listed in the legislation, but the Act goes further, and it states that it requires the laws to be made and interpreted in a way that's compatible with the rights protected under the Act. So that extends to other pieces of legislation that need to be interpreted in a manner consistent with the Human Rights Act. That's quite far-reaching. It obliges the public sector to make decisions in a way and act in a way that's compatible with the rights. Now, you note that there's a specific focus there on the public sector. We'll come to talk about that shortly. Complaints can only be made about a public entity and only about actions and decisions after the 1st of January when it came into force, so it's not retrospective, unfortunately. So let's look at the rights included. I've listed them all there. I'm not going to read them all out, but you can see that there's a right to education, privacy, reputation, taking part in public life, equality before the law. Now, these are traditionally areas where people with disability have been excluded. Protection of families, children, cultural rights, humane treatment, rights in criminal proceedings. That's particularly interesting. It's quite an area of intersectionality between people with disability, criminal law, mental health, and the right to liberty. It's quite an interesting cross-section. People with disability are traditionally overrepresented in criminal system, unfortunately. So, where does this leave us? So we know that we've got some rights under the Act. Now, essentially, when we're looking at law, we're looking at little boxes. So that's the key to law generally. But in order to have a remedy under the Human Rights Act, we need to essentially answer all of these in the affirmative. So was the decision made by a public entity? So obviously, if it's a private institution, the Human Rights Act is not going to apply. But it's a good start. So it has to be a public entity. Did the decision affect a person's rights? If so, which ones? So you need to identify which out of that list I put up before, which rights are engaged. Is there a law that would prevent the agency from acting differently? So do they have to act in that manner? Is that prescribed by another piece of legislation? Or was there discretion in the way that the entity responded? Has the action or decision limited a person's enjoyment of the rights identified? So there has to be some kind of detriment experienced by the individual. And can the limitation be justified? So public entities are core public entities or functional public entities. So the Act defines that a function is of a public nature. So to be a public entity, they have to function in a public nature. So that includes registered service providers, of public disability services. So that may have far-reaching consequences. So if there's a function of a public nature being performed, arguably that entity is a public entity and therefore the Human Rights Act will apply. So again, it's going to really depend on the circumstances at the time. So if you've done your mental checklist and you think it's a public entity and the decision or the action of that entity has affected a person's human rights, and you can identify which rights have been engaged, and there is no law that's going to prevent them from acting in a different manner. A person has had their rights limited because of that action or decision, and the limitation is not justified, then what do you do? So let's talk about now taking action. You can make a complaint. There's the Queensland Human Rights Act and the Queensland Human Rights Commission and the Australian Human Rights Commission. What I'm referring to today is the Queensland Act, and so I'm referring to the Queensland Commission here. So you need to identify the legislation, it's the Human Rights Act, step through those elements I've just mentioned, identify any exemptions or justifications, and also, and this is a trap for young players, make sure you're within the limitation period. So the limitation period is 1 year after the alleged contravention. Hopefully we're going to see that extended in the future. Legislation is quite different with regard to the limitation date depending on which piece of legislation you're referring to, so it can be confusing. It's worth getting advice, and it is worth filing. If you're not sure, my recommendation to you is get advice and file. You can always withdraw. Once you file, then what does the Commission do? The Commission needs to decide whether they're going to accept your complaint or not. So even if you file and you thought you've stepped through and ticked the boxes and actually you've made a mistake and it's not a public entity or it's a body that's not exercising a public function, then the Commission can throw it out anyway. It's not a cost jurisdiction, which is refreshing in some respects. So you can complain to the Commission and they're going to step you through their processes. So how do you complain? The complaint has to be in writing. It's got to contain details, obviously, of the person complaining. It's also got to obviously contain details of the contravention. The Commissioner decides whether to accept the complaint, and the Commissioner has the power to investigate or refer it to another entity to deal with. The Commissioner notifies the other party, i.e. the person who you think has breached the Human Rights Act, and they're given an opportunity to respond. The Human Rights Commission may conciliate the complaint. Now what that essentially means is everybody gets in the same room together, or thereabouts, and there's an opportunity to discuss the issues. A lot of people, once they feel their rights have been breached or limited, can find that quite confronting. So you are allowed to have a support person present. And just because you complain doesn't mean you're necessarily going to get an outcome that you want. So what happens is the Human Rights Commission prepares a report about the complaint, and they may publish information about a complaint they've dealt with, but they may not. So what are you actually getting out of the complaint? Perhaps a report, perhaps information published, perhaps an apology, but it's not a damages jurisdiction. So it's not like Judge Judy, for instance, where you can go and make a complaint and she'll award costs against a person, or she'll award a certain amount that you have to get paid for your pain and suffering, and perhaps the discomfort of experiencing that entire process. That's not what this is about. So who can complain? The Human Rights Act and the Anti-Discrimination Act cover everybody in Queensland. So you don't have to be a resident or a citizen, you don't have to be a person with disability. Everybody in Queensland is covered. However, For matters of discrimination and for matters of sexual harassment, the person complaining has to be the person affected by the behaviour. So for Human Rights Act, another person can complain on behalf of the person who was affected, but that's not the case for the Anti-Discrimination Act and with regard to matters of sexual harassment. So in circumstances where a person has a disability and they can't make a complaint for themselves, you can contact the Commission, and the Commission can give permission for a parent or a guardian to make a complaint on that person's behalf, but that's on a case-by-case basis. You need to seek permission. There is a contact line for the Commission, so you can phone them and make an inquiry, which is fantastic. So if you're not entirely sure, ring them up and ask, and they can let you know and steer you in the right direction. They can also link you up with a service that can help you. So if you need some support or you need help to put your complaint in writing, particularly for a person with a disability, you might need a bit of extra help, and they can help you. With regard to complaints about vilification because of race, religion, sexuality, gender identity, they can be made by a relevant community entity. So that might be a community group or a support group, or someone from those communities. So once you've made the complaint, the Commission assesses your complaint to decide if there was a contravention of the Anti-Discrimination Act or the Human Rights Act. And the Commissioner has to decide whether to accept your complaint. And they're going to accept your complaint only if they're satisfied that the complaint was made in good faith, that it's about conduct that has affected or is likely to affect relevant persons, and it's in the interests of justice. Then the Commission, so there's the assessment, then they decide whether to accept or reject. If they accept your complaint, then you get allocated a case manager, and they're going to contact a person to make sure they know what's happening next. And they also send a copy of your complaint to the respondent, as I said earlier, who has an opportunity to respond. Now that can be quite confronting for some people, particularly people with disability, particularly with reading a response. That can be quite difficult, and it can contain some information that might be confronting. Now, if the Commission doesn't accept your complaint, they'll let you know the reason for their decision. If your complaint is assessed and accepted, then you proceed to conciliation. And quite a lot of complaints are resolved through that process, because quite often people just feel like they need to be heard and have a commitment that similar behaviour isn't going to happen in the future. A lot of people are satisfied with that. But what happens in the conciliation conference? Generally what happens is there's an opportunity to talk about what happened and how an individual was affected. Then the respondent will get to also provide their side of the story, so they get to talk about what happened and how they responded. You can have breaks if you need to. There's even opportunities to work together and brainstorm how you're going to move forward. You can create binding agreements from conciliation. So if both sides agree on how they're going to settle and an outcome, you can write up an agreement, and that will be binding. But if somebody doesn't comply with that agreement, then you need to take the next step and enforce it in court. So there's enforcement processes, which is the next step, if you do reach an agreement. But conciliation isn't like a hearing. The conciliator is not going to decide who's right or wrong if the law was breached. The Commission doesn't take sides. It doesn't give you advice about any offers of settlement or what you should accept. It's up to the parties to work together to agree on the outcomes. Again, that can be problematic given a dynamic. If the relationship between the parties had broken down such that it got to the stage where there's a complaint that couldn't be settled at first instance with the notification, it's hard to see how the parties might come together to work on a solution collaboratively, but it does happen. So, what outcomes can you expect? Common outcomes are an apology, changing policies, changing practices in an organisation, ongoing training in a workplace so that everyone understands their rights and responsibilities. There is the opportunity to pay compensation, for example, for lost wages if a person was unable to work because of the breach, but there's no damages as such. If the complaint isn't resolved, then how you proceed depends on what act you brought your application under, whether it's Anti-Discrimination Act or the Human Rights Act. So for anti-discrimination complaints, the complainant can choose to have their matter referred back to a tribunal, such as the Queensland Civil and Administrative Tribunal, for a public hearing. Work-related matters go to the Queensland Industrial Relations Commission. But broadly speaking, a lot of matters do end up at QCAT, which is the Queensland Civil and Administrative Tribunal. For Human Rights Act complaints, if it's not resolved, then the Commission can prepare that report that I referred to earlier, and it might even include recommendations that the respondent, about actions that the respondent should take to ensure that future actions or decisions are compatible with human rights. If the complaint's resolved, then the Commission will write it down and ask the parties to sign it. And as I said, if there is an agreement reached, it's essentially binding, and then if a party breaches that agreement, then further steps can be taken. Obviously, each party gets a copy of that, but it's up to them whether, if the agreement is breached, whether they want to take it further, and quite often that can be quite challenging because it's already been a lengthy process to get to that stage. If the matter is referred on, essentially there are steps in that process that have to be repeated. So if the matter is referred to QCAT, the Queensland Civil and Administrative Tribunal, QCAT's likely going to ask the parties to conciliate again. Again, that can be quite challenging, particularly if you've gone through the first time and you weren't successful in resolving the matter. If the conciliation isn't successful, then the dispute might proceed to a hearing, and the tribunal may make orders. The tribunal may determine that the respondent might have to stop doing the action that caused the complaint, might decide that the respondent has to pay compensation, including interest on that compensation. So that's quite interesting. Do specific things to redress the loss or damage. Make a public or private apology or retraction, which can be quite damaging to an entity's reputation. Implement programs to eliminate unlawful discrimination. Pay the other party's legal costs, which could be quite significant at this point in time if you've already been through the process at a commission and now you're going to the tribunal. And declare that an agreement is not legally binding. QCAT can also grant an exemption to allow a personal business to do something that is otherwise unlawful under the Anti-Discrimination Act. So, for instance, advertising that a position is identified or for a particular racial group or for females or a particular gender. And it can also provide opinions on anti-discrimination matters to the Commissioner. So, does it cost you to file at QCAT? No. Does it cost you to file at the Human Rights Commission? No. So, filing itself isn't going to incur fees, but if you need legal representation, that may. So, where can you get legal help? Obviously, private lawyers, but we're going to charge. If you need help and you can't afford to pay a private lawyer, legal aid, I've put some references on the board there. If you are able to, you can access the First Nations Advice Clinic, which is through legal aid. There's also a particular unit at the Human Rights Commission who can assist people who identify as First Nations. There are community legal centres, Caxton Legal Centre, Basic Rights Queensland, and Queensland Advocacy Inc., who have since I drafted this, changed their name to Queensland Advocacy for Inclusion. Still a great bunch of lawyers. So you don't necessarily need a lawyer. Okay, I don't want you to think that this process means that you need a lawyer. You don't, but there are steps that you do need to follow. You can make a complaint, you can go to conciliation. Some people like to get advice from the get-go just because there are some nuances, and it really does depend on your circumstances. So it's not a bad idea to go and get legal advice. If you need a good starting place, there is an opportunity under Legal Aid Queensland. They have a discrimination advice clinic, and I've put the number up on the screen there, so that's not a bad place to start if you're not sure. Again, the Human Rights Commission has an inquiry line, so that's also not a bad place to start. So I'm nearly at time. I did want to discuss a few additional matters because I have been asked to speak to you about the legislation today, which is a little bit dry. However, talking to many of you today, most of your questions have been around guardianship and decision making, and that's something that I just wanted to spend the last couple of minutes on before we go to questions, if that's okay. So essentially, when I've been talking to clients, they've been saying, well, who can make decisions for me if I need help? So if you are hit by the proverbial bus, unfortunately, hopefully none of us in this room ever are. But the response to that is it depends on the kind of decision being made. If it's a health decision, typically there's going to be someone who can stand in your shoes and make decisions for you. So it might be a family member or a partner or a friend who can step in and make those healthcare and medical decisions. And generally that happens automatically. So if there were a tragic accident to happen, somebody is going to step up and make those calls. And they're really time precious, and that's why the legislation allows for someone to act in that role. And that's called a statutory health attorney. The Office of the Public Guardian provides an outline on that. I've also got that linked on my website if you want that as a resource. It's not a bad thing to have a bit more information about. Traditionally, the problem happens when finances need to be accessed. So if you were in an accident and there are medical bills that need to be paid, someone may or may not have access to your funds to pay those bills. Traditionally, that's when an application has to be made to the Queensland Civil and Administrative Tribunal on your behalf. The tribunal does a great job. They work very hard. They are very, very overworked with the funding that they receive. However, a lot of the pain that your family goes through, so they're dealing with something that's happened to you, but they also need to jump through these steps. And as I said, law is a lot of boxes. There's a lot of boxes that need to be ticked. So an application has to be made. They need to demonstrate that you lack capacity. They need to demonstrate that there's a need for decisions to be made. And they need to demonstrate that they're the most appropriate people for the job. So they need to get all that paperwork together while they're worried about you and while they're trying to hold the pieces together. And it's absolutely possible that the tribunal might appoint the person who's applied, but they might not. So it's open to the tribunal to appoint anybody the tribunal thinks is the most appropriate person in the circumstance. And that includes the public trustee. And that may not be the entity that you would like controlling your money if you can't. Now, a lot of that can be avoided with a bit of future planning. So I've been talking to a lot of people today about the importance of making enduring powers of attorney. We hope that those documents are never used. It's a bit like insurance. You pay for it and you hope that you never need it. But if you don't need it, then it's just a piece of paper that sits in a drawer. But if you do need it, it can make all the difference because it means that your family doesn't have to go through that process. And I've talked today about the Human Rights Act and the Anti-Discrimination Act. And those pieces of legislation are so valuable, and we're so grateful for them. But to state the obvious, if you are a person with disability or you lack capacity, whether it's permanent or temporary, how do you enforce those rights on your own behalf? You obviously need somebody to act on your behalf. So there's not really much point in having remedies without a person to enforce them. So it's so important, even though we might be well at the moment, to think ahead and make sure that we've got someone who is able to act in our stead for those moments if, and we all pray that it's never going to happen, if it does eventuate. So I don't mean to put a bit of a downer on this afternoon, but I certainly advocate that taking some action now might be beneficial down the track. Has anyone got a question? It doesn't have to be on human rights or anti-discrimination. I'm happy to take a question without notice.
The enduring power of attorney, is that the same as your health? Like, say you had an accident, and does that mean it's included in the EPA?
Yeah. Okay, so sure, essentially the enduring power of attorney document is appointing a person to stand in your shoes as your proxy, and they're going to make decisions on your behalf. Now, because we function in boxes, we talk about the health box and the financial box. So the enduring power of attorney is going to appoint a person or persons to make decisions about either or both of those boxes. Now, it's giving a person the power to act on your behalf. It's not telling them per se how to use that power. So if you'd like to give some more detail about how that power should be exercised, i.e. the medical decisions to be made, and the question I get 10 times out of 10 is, does this give them the power to turn the machines off? Yes, it does give them the power to turn the machines off, but it doesn't tell them that they should. So if you'd like to be specific about how those powers should be exercised on your behalf, the Advanced Health Directive is the document that does that. So that's the end-of-life measures document that talks about what decisions should be made on your behalf. Having said that, it doesn't mean that you couldn't make, for instance, a vision plan outlining what you'd like your life to look like. But having said that, it's very hard to get my clients to comply with some basic documents. So it's really up to you how much you'd like to do. And that's why quite a few times when clients come to me, I'll give them an additional document that they can fill out at their leisure, which will specify what their vision plan and their wishes are in detail.
There was another one earlier that we spoke to about superannuation. That's not included in the will? If you made a will, is that a...
Okay, so the question was, is superannuation included in your will? The answer is, generally speaking, no. I'm going to be a lawyer and I'm going to say it depends. Generally speaking, no. So the Superannuation Industry Supervision Act is what applies to superannuation, and the Succession Act applies to your will. So they're completely different pieces of legislation. You can direct that your superannuation is funneled from the super legislation into your estate to be distributed according to the terms of your will, but that's a directive you have to put into your super.
It doesn't take much, does it? It's just a form and it's done.
It's just a form.
It's a good one to do.
Absolutely. The trap for young players is that quite often, after 3 years for a lot of super funds, your nomination will lapse. So a lot of people have done it. They say, I've done a nomination when I started my job 20 years ago. And I say, well, let's revisit that.
That was great.
They don't necessarily tell you that. Some super funds will, but essentially it's your responsibility to follow that up. Quite often on your member statement each year, it'll list who your beneficiaries are. You also need to consider who you've nominated. So you can only nominate a spouse, a child, a financial dependent or an interdependent, or your legal personal representative. So I couldn't, for instance, nominate my sister to receive my money that I've voluntarily contributed to super or contributed over the years, because she is not an eligible applicant.
There's a question, lady, over here earlier. You had a question, ladies?
I was just wondering about the human rights. We've got the state and then the federal. What's the, like, every state...
Can we get the mic to you? Can we?
Oh, sorry. So, with the Human Rights Act, we've got the federal and then the state, and each state would have their own human rights act. So which one is precedent? Why do all the states need one? Why doesn't the federal one cover everything?
So there is no federal Human Rights Act. There's only a Queensland Human Rights Act and a Victorian Human Rights Act. And the Victorians like to think they're trendsetters because they had theirs first.
We are.
There we go. So quite often when we are, because our legislation is so young, we do quite often look to precedents that have been set in Victoria and also the UK. So yes, there is a lot of law coming out of Victoria that we are looking to for guidance. I'm on the Queensland Law Society Committee for Disability and Health, and we do try and keep abreast of what's happening in other states so we can make representations to our Parliament or suggestions as to how laws could be improved. But yes, there is a Queensland one and there is a Victorian one. There's no federal. The Constitution, which doesn't really enshrine any rights, sorry. So basically you're relying on the Human Rights Act or the Anti-Discrimination Act applicable in any state and territory. You also need to consider where the offence or the complaint originated. So obviously if you're in Queensland and the event that you're complaining about happened there, Queensland would be the jurisdiction.